be of me today. I am on cloud nine for at least another few weeks. My very first grandson, Theo Alberto Ramos Mitnick, all 4.5 pounds, 18 inches. He's a little guy, but he is doing well. Mother's doing well, so couldn't be better. In any event, we are here to talk about something just as fascinating, requests for reasonable accommodation, managing employees under the ADA, everything you want to know about your duties and responsibilities under the ADA and applicable state law. Now, I'm going to get into the whole idea of this is to make it kind of practical for you. So when these issues arise, you know what to do. You are free to ask questions at any point in time. I'm going to ask you all to open up the chat box, which may be one of the easiest ways for us to communicate. You are free to interrupt me anytime you want. I'm just sending you a chat message right now. Greetings from Springfield, Massachusetts. I'm sitting in my office here. So hopefully all is doing well. All right, so what I want to do is first kind of dispel some of the myths about the Americans with Disability Act and our obligations under state law. The American Disability Act does not give people with disabilities preferences. It does not give them the right to a job. All the laws are designed to do is to give them equal opportunity, whether it be in the application process, when they how to apply for a job, whether give them equal opportunity to perform the essential functions of the job. We'll get into that in a lot more detail, and to allow employees with disability to enjoy equal benefits and privileges of employment, right? Equal privileges of employment. We'll get into that. The law is not designed to give people with disabilities preferences. It does not mean we're going to ignore performance issues. And for those of you who attended the training I did last month on toxic employees, one of the mantras that I said is that as managers and supervisors, you have to address every performance issue, no matter how minor, in a prompt and effective way. And you have to do that consistently with all your employees, whether they have disabilities or they don't have disabilities, whether they're young or old. So we are not giving preferences to employees. We're just trying to ensure they give equal employment opportunity. Now, to give you kind of a macro perspective of where this all comes into play, I have a list here of protected characteristics, and I'm sure you're all familiar with the concept that we cannot discriminate based on any of these protected characteristics: race, color, national origin, ancestry, age. And nor can we discriminate against someone based on the fact they have a disability. And you'll see that there are three groups out there that have asterisks next to them: religion, disability, and pregnancy. And those are the three areas where we have to provide, or may have to provide, reasonable accommodations. Reasonable accommodations only come up in the area of disability, religion, and pregnancy. And I will be happy to entertain any questions you have about reasonable accommodations for religion or pregnancy. But our focus today is going to be on reasonable accommodations for disability, which may be probably the most complex, difficult area of the law to understand, at least in terms of unemployment law. Now, in order to really introduce yourself to the concept of reasonable accommodations for disability, I need you all to repeat after me. And I did this with our class, Toxic Employees, but I want to try it real time. So I want everybody to take their computers off mute. Let's see if we can get this synced. All right. We all ready? All right. Repeat after me. I am not a doctor.
Doctor.
That was actually pretty good. Pretty good. All right. Put yourselves back on mute. And you can take yourselves off mute if you want to ask me a question. But I am not a doctor. And the reason why we have to harp on that is because the only individuals who can determine whether or not someone has a disability is a medical professional. The only individuals who typically can determine what's the appropriate reasonable accommodation are medical professionals. And where we get in trouble more than anywhere else in this area of disability discrimination is when managers and supervisors try to diagnose whether employees have disabilities. Where we get in trouble is when managers, supervisors unilaterally decide whether or not to provide an accommodation. You can't make those decisions. Now, I'm going to talk a lot about human resources today and how obviously you should reach out to human resources. But I know some of you may not have that, may not have a human resources department, or you in fact may be human resources. But one of the things I am going to emphasize is the importance of having some expert assist you with these type of issues, because they can be very complicated, very problematic, and unfortunately result oftentimes in litigation. So I would not go down this track alone unless you actually do have some experience. But I do want to obviously point out, as you as supervisors and managers, what you have to be aware of under our reasonable accommodations statutes. Now, when we talk about what's your responsibility as a manager or supervisor, it is primarily to do one thing: spot when the issue arises, report the issue to human resources, and trigger the reasonable accommodation process. That's it. Spot, report, and trigger. And the reason why I want to doubly emphasize this is because, again, you're not a medical professional. And by the way, I'm going to guess that there may be a couple of medical professionals on this call, but unless you're actually treating that employee, you cannot diagnose them, right? Your role is a supervisor. So it's spot when these issues arise, report to HR, and trigger the reasonable accommodation process. Now, there are three critical events when a manager must spot, report, and trigger the reasonable accommodation process. And the first triggering event is when that disability is open and obvious. Open and obvious. Again, under the American Disabilities Act, it literally says that anytime a disability with an employee or an applicant is open and obvious, we are obligated to trigger the reasonable accommodation process. So what I mean by open and obvious, we have an applicant who comes in for a job interview and they're wearing the big thick black sunglasses and walking with a cane. Well, it's open and obvious they have a visual impairment. Alternatively, we may have an employee that needs a wheelchair for mobility. Well, it's open and obvious they have a physical impairment. And because those impairments are so open and obvious, we are obligated to trigger the reasonable accommodation process. So to give you a good example of open, obvious, reasonable accommodation disability discrimination, it's a true story. A local college near us, they had a faculty member, a female faculty member who worked for there for many years. And since she worked there, she's always needed a wheelchair for mobility. And this department decided to schedule a mandatory staff meeting for all faculty. And they scheduled that meeting in the second floor of a building that was not handicap accessible. That's open and obvious disability discrimination. Because that employee's disability was so open and obvious, they should have obviously triggered the reasonable accommodation process and scheduled that meeting in a handicap accessible room. The second triggering event is when an employer applicant requests a reasonable accommodation, Now, as I'm going to emphasize, the employee does not have to say, I have a disability. The employee does not have to use the words, I want a reasonable accommodation. Any plain English, broad and general terms will suffice. So, for example, maybe an applicant during an interview will voluntarily disclose, hey, I just want to let you know I have diabetes and I need to take a break every hour and a half to 2 hours to check my blood sugar and eat a little something. That's a request for reasonable accommodation. An employee may come up to you and say, look, I'm having some chronic back issues. I'd like an ergonomic chair, one of those stand-up desks. That's a request for reasonable accommodation. We may have an employee that has some physical ailments, like maybe carpal tunnel syndrome, and would like a wrist brace and ergonomic keyboard. That's a request for reasonable accommodation. Someone may have some visual impairments and wants special computer screens, or hearing impairments and wants an amplifier for the phone. Or maybe we have an employee that's dealing with alcoholism issues, and alcoholism is a disability. And they ask the supervisor to leave every Thursday an hour early to go to an AA meeting. That's a request for reasonable accommodation. And anytime an employee or applicant requests a reasonable accommodation, we have to absolutely trigger the reasonable accommodation process. And if I start talking too fast, just slow me down, ask any questions that come to you. Again, we have a small enough group where you feel free to interrupt me. And now the third event. And this is actually, in many workplaces, the largest cause of discrimination complaints. And that is when an employee has a performance issue related to a disability or medical condition. Employee has a performance issue related to a disability or medical condition. So let's create a scenario. Let's say we have an employee with some serious performance issues, constantly showing up late, not getting the work done in a timely manner, making a lot of mistakes and errors. Well, the manager has to speak to that employee, right? So the manager goes up to the employee and says, "Hey, what's going on? This is the third time in the last 2 weeks I've been late. You're not getting your work done in a timely manner. You're making a lot of mistakes and errors. What's going on?" And the employee may say something like this, say, "Well, about 3 months ago, I saw my doctors and they diagnosed me as having chronic depression. I'm now on antidepressant medication, and it's really hard for me to focus and concentrate, particularly first thing in the morning. Bing, 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 bells and whistles are going to go off. And what is that manager going to do?" Feel free to type it into the chat box. What is that manager now going to do? Anybody know? Uh, engage in a conversation with the employee? Not exactly. I see you all. Report and trigger. Yes. Oh, Heather, you're way too fast. You're advanced. All that supervisor or manager has to do is inform the employee or applicant that they will contact HR and then contact HR. Spot, report, and trigger. Again, it is not your duty responsibility to determine if they have a disability. It's not your duty responsibility to determine what's appropriate reasonable accommodation. It's only your obligation to spot, report, and trigger. So, some good advice that I can give you is anytime an employee has a performance issue, you need to be really attentive to the reasons the employee gives for their poor performance. Because if that employee mentions anything about a medical condition or disability, bing, 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 lights and whistles go off. You trigger the reasonable accommodation process, contact HR. On the other hand, if the employee gives you any other reason or excuse for their poor performance, such as alarm clock is broken, car broken down, walking 10 miles each way to work, the T or the public transportation is always late, problems with the spouse, problems with the kids, got a new puppy keeping me up all hours, staying up late to watch Jimmy Fallon, you own those issues and you engage in performance management. But if the employee mentions anything about a disability or medical condition, bing, 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 we have to spot and report or trigger the reasonable accommodation process. All right. Any questions about this so far? All right. Great. Great. So, what I want to do is go through a number of scenarios. And I want you to indicate, just type it into the chat box, yes or no. Will this obligate a manager to trigger the reasonable accommodation process? All right. So here's just a little bit more details. As I mentioned, uh, we are obligated anytime the employee needs mentions that they need adjustment or change of work. They can use plain English. They don't have to mention the ADA, term disability, or reasonable accommodation. And very importantly, verbal requests are legally sufficient to trigger the reasonable accommodation process. Just an employee coming up to you and saying, "I'd like one of those ergonomic stand-up desks because I'm having chronic back issues," is enough to trigger the reasonable accommodation process. All right, but let's go through some scenarios. An employee tells their supervisor, "I'm having trouble getting to work at my scheduled starting time because of the medical treatments I'm undergoing." Yes or no, will this trigger the reasonable accommodation process? Just type in your answers chat box. And everybody's saying yes. Excellent. Of course, the answer is yes. Yes. Okay. How about this scenario? An employee tells a supervisor, "I need 6 weeks off to receive treatment for a back problem." Yes or no, will that trigger the reasonable accommodation process? I see everybody saying yes, and very good, because the answer clearly is yes. How about this one? An employee is consistently late for work, and each time the employee says, I did not remember to set my alarm clock, and I have a hard time getting up in the morning. Will this trigger the reasonable accommodation process? Well, you're all batting 100 because the answer clearly is no. There's no mention of anything related to a disability or medical condition there. So you're not obligated under the law to spot report trigger. All right. How about this one? An employee tells his supervisor he would like a new desk chair because his present one is uncomfortable. Yes or no? This trigger the person. The answer is no. There's no mention of anything that's even closely related to a disability or medical condition. Now, if the employee said they want a new desk chair because they're having chronic back issues, that's a different story. But just because they're uncomfortable, and that does not trigger any legal obligation of us to do anything. How about this one? An employee's spouse telephones the employee supervisor on Monday morning to inform her that the employee had a medical emergency due to multiple sclerosis, needed to be hospitalized, and thus requires time off. Yes or no? Would this trigger the reasonable accommodation process? I'm glad everybody's saying yes. Now, very importantly, the employee themselves doesn't necessarily have to be the one that puts us on notice. It can be the employee's spouse or family member. It can be a lawyer, such as we get a letter, from a lawyer or an email from a lawyer saying, please provide this accommodation to this employee, or it could be a medical professional, such as a doctor's note. I mean, not that I want to sound dramatic, but the employee's in a coma. Are we going to require them to actually call us and let us know that they can't come to work that day? No, but it's clearly can trigger the reasonable accommodation process. How about this one? An employee's been out of work for 6 months with workers' compensation injury. The employer doctor sends the employer a letter stating the employee is released to return to work with certain work restrictions. Yes or no, will this trigger the reasonable accommodation process? And the answer is absolutely, positively yes. Now, very importantly, under Massachusetts state law, if someone is approved for workers' compensation, there is a presumption that they have a disability, which means typically when we're dealing with workers' compensation issue, modifications, limitations, what they can do, chances are we're going to have to go through the reasonable accommodation process under the ADA as well. Okay. Now, just so you know, workers' compensation means that someone was injured on the job. But obviously, for reasonable accommodations under the ADA, it can be someone could be injured on the job, or they can be suffering from something outside of work. Okay, that doesn't matter for purposes of the ADA. But just so you know, when there's a workers' compensation issue, it usually triggers the ADA reasonable accommodation process. How about this one? An employee says to an employer, I'm having trouble reaching tools because of my shoulder injury. Yes or no, would that trigger the reasonable accommodation process? The answer is absolutely, positively yes. We have a shoulder injury, medical condition. Absolutely. How about this one? An employee indicates that she has severe environmental allergies and cannot come to the office unless significant accommodations are made. Yes or no, will this trigger the reasonable accommodation process? And I'm glad everybody's saying yes. And this is a very common one. For any of you that work in old buildings, we know that mold can sometimes be a very dangerous allergen, and allergies absolutely can be a disability. Absolutely can be a disability. Now, someone asked the question, what about the FMLA? And actually, I am going to address the FMLA at the end. Right. So, but FMLA is all the FMLA gives people is a leave of absence. Here, we may actually have to do a total modification or rectify the mold or allergy situation in the building. That may be the appropriate reasonable accommodation. All right. Any other questions on this one? All right. How about this one? An applicant smells of alcohol during an interview. Yes or no, will that trigger the reasonable accommodation process? And I'm glad you're all saying no because the answer is no. Judy, you are 2 steps away ahead of me, so just slow down. I'm going to get to essential functions in just a minute. Okay. The answer is no. Now, very importantly, when an applicant comes in and they smell, whether it smells of alcohol, it smell of BO, um, you are not going to write in your notes that the person is an alcoholic because you can't make that diagnosis. Now, the truth of the matter is the employee may have been drunk uh, the night before, may have gone on a bender, but that doesn't necessarily mean they're an alcoholic. Your job is just to assess that whether they have the ability to do the job. And if someone obviously comes in and they smell for whatever reason, that is justifiable grounds for not hiring that individual. But are you obligated to trigger the reasonable accommodation for that individual? The answer is no. Okay. Um, Now, someone wrote a good question. When did allergies and depression come with disability compared to blindness or some other paralysis? There's a difference between those two disabilities and validation of that condition. Well, truth of the matter is, allergies and depression have always been considered disabilities, and we're going to get into exactly what we mean by the definition of disabilities in just a moment. Right now, that is essentially what we went through. The spot report and triggers, really the basics, essentials of what managers need to know. But now we want to get into a little bit more nitty gritty and go into really what the reasonable accommodation process entails, what HR, whoever's handling this issues, what's the type of analysis they have to go through. So let me explain it to you this way. In order for that employee to get a reasonable accommodation, they need to go through 4 doors. 4 doors. These are the 4 doors of the ADA. The first door is the employee has to have a disability. And that's a little bit actually more complicated than you think because there's actually 3 different ways an employee can be deemed to have a disability. Secondly, they have to be able to perform the essential functions of the job, essential functions. And then if an employee has a disability and can perform the essential functions, then we engage in interactive dialogue with the employee and determine what's the appropriate reasonable accommodation. And we're obligated to give that employee reasonable accommodation unless it would cause an undue hardship to the operations of the business, operations of the employer. Right. So the 4 doors again, the employee has to have a disability. Employee has to be able to perform the essential function job without a reasonable accommodation. We then engage in interactive dialogue and agree to reasonable accommodations, unless that reasonable accommodation would cause an undue hardship. So let's go through these doors step by step. And the first door we go through is a disability. Obviously, the employee has to have a disability, and there's actually a very multiple different ways in which an employee can be deemed to have a disability. The first one is they have what we call an actual disability. And disability is defined as a physical or mental impairment that substantially limits one or more major life activity. A physical or mental impairment that substantially limits one or more major life activity. And when people think of substantial, it usually means chronic. Chronic. So even though they may have minor arthritis, that could still be a substantial limitation, or asthma. So first of all, what do we mean by a major life activity? Well, essentially, it's everything we do as human beings. We walk, talk, eat, think, hear, smell, speak. And if we have any condition that substantially limits our ability to do any one of these human functions, it will be a disability. And there are hundreds and hundreds and hundreds of medical conditions that rise to the level of a disability. And they include arthritis, asthma, Crohn's disease, any form of cancer, chronic back issues, chronic heart disease, fibromyalgia, um, Lyme disease, depression, anxiety disorders, schizophrenia, alcoholism, addiction to controlled substances. Okay. And I can go on and on and on and on and on. And as long as any of these ailments substantially limit one or more of these major life activities, it will be a disability. Without a doubt, it will be a disability. So that's the first way it could be deemed to have a disability, is if you have an actual disability. But it gets a little bit more complicated than that, because you can also be deemed to have a disability if you have a record of a disability. So what do I mean by that? Well, let's say we have an employee who 5 years ago had a bout of prostate cancer. But they beat it, they kicked it. They are now cancer free, total remission, and they're no more likely to get cancer than anybody else. Well, even though they're not suffering from cancer now, either though they're cancer free, because they have a record of prostate cancer, they have a record of a disability and still deemed to have a disability under the law. Another good example is someone with an alcoholism issue. Now, they may have been sober for the past 15 years, have not had a sip of alcohol in the last 15 years. But if that employee can show they have a record of alcoholism, they're deemed to have a record of disability and still deemed to have a disability under the law. Now, someone wrote, what disability and handicap, different terms? No, they are synonymous for purposes of this discussion. Disability and handicap are synonymous. So that's the second way someone could be deemed to have disability, if they have a record of disability. And now the third way, and this is an area where manager supervisors are getting in trouble so often, and that is when we regard or perceive someone as having a disability. So let me give you an example. Let's say we have a custodian, right? Employee who's a custodian. And they come to you one day and saying, look, my back is really hurting me. I don't think I can lift the trash barrels, 50-pound trash barrels, or lift anything over 50 pounds. Is there any sort of light duty I can do? Maybe push them up, sweep the floors, or do some paperwork? And manager says, sure, yeah, you don't have to lift anything heavy today. Just sweep and mop the floors, right? Now, this happens once every 2 years, not a big deal. But then the employee starts complaining about their back and wants light duty every couple of months. Then the employee starts complaining their back is hurting, light duty every couple of weeks. Then the employee starts asking for a light duty assignment every other day. Well, even though this employee was never diagnosed as having a chronic back issue, even though this employee never went to a medical professional regarding their alleged chronic back issue, because we regarded them or perceived them as having a chronic back issue, they're deemed to have a disability under the law, meaning they are deemed to have a disability even when they don't, if we treat them as if they do. Give you another good example. This took place in an office environment where an employee who went up to her manager and said, look, I have a really bad migraine. Is it okay if I turn the lights out on my desk and put my head down for a little while? The manager says, sure, of course, no problem. And again, this happens every year or so, not a big deal. But then the employee starts complaining about migraines every couple of months. Then the employee calls the manager first thing in the morning and tells the manager, hey, I woke up with a bad migraine this morning. Is it okay if I work at home? And the manager says, sure, that's fine. Well, again, even though this employee was never diagnosed as having a migraine, even though they never went to a medical professional for their alleged migraines, because we treated them or regarded them as having migraines, they're regarded to have disability and deemed to have a disability under the law. So let's get real. Practical application of these concepts. An employee, we'll use a custodian as example, comes to you and saying they're having some chronic back issues and like some light duty. What are you, the manager, going to do? What are you going to do? Anybody know? Just type it in the chat box if you know. No, Judy, we are not going to panic. Maggie, you went a little too far. Spot, report, and trigger. Spot, report, and trigger. Contact HR. Are they giving you a medical condition that is impacting your ability to do the job? The answer is yes. Spot, report, and trigger. Contact HR. Remember, anytime the employee gives us a medical condition or a disability as the reason excuse for not doing part of their job, we have to trigger the reasonable accommodation, contact HR. Right? Anybody have any questions on this? And feel free to take yourself off mute. Judy, good question. What can you do if there is no HR? Well, my advice to you is to contact an HR specialist. Have someone on retainer. There's a few of them, many of them out there. A lot of lawyers do this as well, which can help you guide you through the HR process, because you don't really want to necessarily be the one to make those important decisions, right? And what will HR do? HR will go through the process that we're talking about right now. Okay. So yes, we will be asking that employee to bring back medical notes. Absolutely. Absolutely. That's what HR would do. We'll bring back medical notes. We'll get notes or information from the medical professionals, and then have an interactive dialogue. So we'll go through that process. But this is essentially the process that HR has to go through. Any other questions about this at this point? I can feel your nervousness. No, Kathy, you're not always required to provide light duty, and I'll get into that in a minute. Okay. All right. So that's just door number one, which now brings us to door number two. And door number two is essential functions. In order for that employee to get that reasonable accommodation, they have to be able to do the essential functions of the job with or without reasonable accommodations. Essential functions. In other words, is that employee, even though they have this disability, otherwise qualified for the job? So let me give you an example. Let's say, as I'm sure many of your senior centers do, you have employees that work as van drivers, right? Or car drivers. They go around and pick up the seniors, right? Well, let's say, unfortunately, one of these drivers was in an accident. And as a result of that accident, this driver can no longer drive. They lost their license. They are legally blind. Is this employee capable of doing the essential functions of the job as a driver? Yes, yes or no? Type in chat box. No, no, which means they are not entitled to reasonable accommodation, and we have no other obligation to provide them. Okay. The law does not require us to find or create jobs for these individuals. If an employee can't do the essential functions job, we have no reason to employ him, and we can actually terminate that employee. In fact, I would recommend you do terminate that employee. Think of it this way. Are we going to continue to employ individuals who can't do the basics, the essentials of the job? The answer is no. Our only obligation is to provide reasonable accommodations when they can do the essential functions, with or without reasonable accommodations. Okay. And Kathy, I'm going to get into COVID issues in a little bit. Right. Let me give you another example. Let's say we have an admin or a secretary who's having some performance issues, just not getting their work done in a timely manner, making a lot of mistakes. So the manager goes up to that employee and says, "Hey, what's going on? You're not getting your work done. You're making a lot of mistakes." And the admin secretary says, "Oh, my wrists are killing me lately, and it's really impacting my ability to type." Bing, 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 spot, report, and trigger. The employee then comes back with a doctor's note, and the doctor's note diagnoses the employee's having carpal tunnel syndrome and says, if we give this employee 1 week off to rest, secondly, give them a wrist brace, and third, an ergonomic keyboard, this employee would be able to type as fast and as capable as they would beforehand. So my question to you is this admin capable of doing the essential functions of the job with a reasonable accommodation? The answer is absolutely yes, and they move on to door number 3. Anybody with me still? Now, there is one tiny exception to this concept of essential functions. As I mentioned earlier, we have no obligation to create a job for someone who can't do the essential functions position. But we may be obligated to reassign that individual to a vacant position if they're qualified for that position. Job reassignment of a qualified employee to a vacant position. So let's go back to our driver, who clearly can't do the essential functions of the job as a driver. but we have a vacant position in the office for which that employee would otherwise be qualified for. Well, then we may be obligated to reassign at that position. But that requires two things. It requires number one, a vacant position, and secondly, that they're qualified for the job, right? Um, and and those are the only circumstances where we really have to reassign someone when they can't do the essential functions. All right. Any other questions about essential functions? All right. Very good. So now we are at door number 3. And assuming the employee does have a disability, can do the essential functions job, we are now obligated to have an interactive dialogue with the applicant or the employee. And that is an informal discussion about possible reasonable accommodations. We cannot simply say, no way, we're not giving you an accommodation. We can't say to an employee, here's the accommodation, love it or leave it. It's an informal, interactive process. And this is typically done by human resources. But since some of you don't have human resources, you may be obligated to discuss this. And so what you do is you review the medical documentation, you talk about the aspects of the job, what will work, what will not work. Again, it's an informal process. And ultimately, we have to provide that person with a reasonable accommodation. Now, reasonable accommodation in broad terms can be any modification of the workplace. It can be a modification of schedules and hours. It can be a modification of policies, or it can be a leave of absence. Okay. So I'm just going to go through, these are long lists of possible reasonable accommodations. It's really an endless list, but acquiring, modifying equipment or devices, job restructuring, creating part-time and modified work schedules, reassignment to a vacant position, adjusting and modifying examinations, training materials, policies, providing readers or interpreters, making workplace readily accessible to and usable people, such as modification of bathrooms, probably ramps, guardrails, handrails, granting and extending leave of absence, right? These are reasonable accommodations involving communications, such as software for standard employee computers and other equipment that can enlarge print to convert print documents to spoken words. Here, speaker phones, telecommunication devices for the deaf, right? Removing communications barriers, such as putting up braille signage or flashing fire alarms, right? Again, any modification of the workplace, right? Structural changes. What about different furniture, office layout, equipment adaptations, bathroom modifications, special door openers, right? Now, the reason why I emphasize very importantly that you should be consulting with an expert on this is because the amount of modifications, possible reasonable accommodations, in many cases can be endless. And you really need to know someone who has some expertise. I know a lot of you are saying, oh my gosh, where am I going to pay for this? Well, truth of the matter is there are a lot of resources out there that it will pay for reasonable accommodations. The Massachusetts Association for the Blind, they readily provide employers free of charge with special computer equipment, um, computer screens, software to enable people with visual impairments to work in jobs, right? And so you really need to sometimes you need someone who has that insight, has that experience, and knows where to get the important information you need to make a reasoned judgment of what's appropriate reasonable accommodation. Now, also, what can be a modification, reasonable accommodation modification of policies? So, for example, I know in some workplaces they have policies that you can't eat at your desk. Can't eat at your desk. Well, what if someone has a severe case of type 1 diabetes and they're worried about going into diabetic shock and they'd like to keep a glass of orange juice or a candy bar in their desk? Would that be a reasonable accommodation? More often than not, yes. In which case, then we have to modify our policy. Everybody with me? Any questions at this point? Other examples of reasonable accommodation, flexible scheduling, delayed start time, telecommuting. Telecommuting can be absolutely be a reasonable accommodation under the circumstances. Now, of course, if someone is working as a receptionist or a custodian, then obviously reasonable telecommuting would not be reasonable under those circumstances. So that's why we put the term reasonable accommodation. It has to be reasonable under the circumstances. Now, we are obligated to provide that accommodation unless it would cause an undue hardship to the operations of the business, undue hardship to the employer. Now, typically, when people think of undue hardship, the first thing they think of is the cost of the accommodation. And in theory, under the law, we can take the cost of that accommodation into account. But I'm going to guarantee you, for most of you that work for public municipal senior centers, cost will never be a factor because under the law, we have to compare the cost of that accommodation to the total revenues of the employer, meaning the total revenues of that city and town. So comparing the cost of accommodation to the revenues of any city and town, is any accommodation going to be too expensive? The answer in all likelihood is no, no. So as much as in theory, cost can be a factor, in all practical applications, cost is never going to be a factor. But let's change the facts a little bit. Let's say we have a mom and pop package store, right? And we have an employee that's in a wheelchair. And they want the package store, the owners of the package, to build an elevator so they can go down to the basement. Well, could that package store be an undue hardship? I mean, excuse me, could building that elevator to that package store be an undue hardship? The answer is absolutely yes. So when do we get into issues of undue hardship? Well, really, when it really impacts the nature and structure of the operation. So let's say, and I'm not sure this is applicable to any of your places, but let's say you need a team of 3 people to do a job. And this team always shows up at 8 a.m. and they stay till 4 p.m. But someone has a disability, asks for an accommodation, and what they're asking is instead of starting it and working from 8 to 4, they work to 9 to 5. But that would mean also changing all the other employees' hours so they work to 9 to 5. That would be an undue hardship because that is interfering with the nature and structure of operations. And generally speaking, if it's going to impact other employees, usually that can be an undue hardship. Now, I want to warn you, I'm going to put on my legal hat for a second. Courts, the Massachusetts Commission Against Discrimination, MCAD, they really don't like when an employer denies an accommodation for undue hardship. They will scrutinize that rationale. So if you are going to determine that you can't provide an accommodation for undue hardship, you better have the facts, the data, the details to back it up. And I would obviously advise you to talk to your legal counsel before you actually make that decision, because that is very likely to result in a complaint to the MCAD. All right. Any questions about any of these doors at this point? All right, very good. So as all these cases, and I wrote here, employers must determine undue hardship on a case-by-case basis. But truth of the matter is, every single disability reasonable accommodation request has to be cited on a case-by-case basis. Simply because you provided a certain accommodation to someone who had a chronic back issue doesn't mean the next employee comes in with a chronic back issue gets that same accommodation. You have to go through a separate case-by-case analysis with each individual. Now, as someone have already raised issues about the Family Medical Leave Act, and that it does play a role here. And oftentimes, when someone is eligible for reasonable accommodation, they're also eligible for FMLA. Not always, but sometimes, right? So I want to make sure that everybody has a good understanding of why the FMLA exists and how it is separate and distinct from this reasonable accommodation process. Now, I'll be honest with you. I remember, I'm giving away my age here, but I remember what life was like before the FMLA. I worked for the city of Holyoke, and we had employees that would be disciplined for abusive sick leave or excessive tardiness. And They would file for arbitrations on the grievous contracts or maybe silver service hearings. In any event, what I used to do in those cases, get one of those big desk calendars and put a red X over every day the employee was tardy or absent. And I used to hold it up to the arbitrator because the picture is worth 1,000 words. And it would show that the employee was constantly calling out sick on Mondays or Tuesdays after a long weekend, or coming in late on Monday, or calling out sick on Fridays. It was clear that they were abusing sick leave or they were engaging in excessive tardiness. But then the Family Medical Leave Act came into play, and it changed the whole way we addressed leaves of absence and tardiness issues. Because now the employee may be entitled to that absence. They may be entitled to come in late or leave early. Now, the FMLA is very confusing, and I want to start by focusing on the eligibility requirements. Now, as we were talking about just a few moments ago, we're going to talk about the ADA. People are entitled, I should say employees are entitled to a reasonable accommodation even before they walk into the door. We have to provide applicants with reasonable accommodations, and employees on day one may be entitled to reasonable accommodations, but not under the FMLA. In order to get a leave of absence under the FMLA, the employee has to have worked for us for 12 months and 1,250 hours within the 12 months. And ignore, I have references here to New Jersey, obviously, that's where I gave my last training, so ignore that, right? 12 months. So part-time employees may not be eligible for FMLA. New employees may not be eligible for the FMLA. They're only entitled to FMLA if they work for 12 months and 1,250 hours within the past 12 months. Now, very importantly, when the FMLA was enacted approximately almost 30 years ago now, I believe, it thought it was be a really easy to understand law, really easy to implement, because the only thing the FMLA provides is an unpaid leave of absence without loss of job, without loss of benefits for any FMLA triggering event. That's it. That's really the essence of what the law is about, is an unpaid leave of absence without loss of job, without benefits for any FMLA triggering event. Now, if I haven't confused you yet, I will confuse you, okay? But there's a method to my madness, right? What makes this confusing is, on the one hand, we have this law, which provides an unpaid leave of absence. On the other hand, we have our municipal benefits, such as sick leave, personal leave, vacation time, paid time off. Do not confuse the two. In order to understand how the law works, you have to separate out what are municipal benefits from the statutory unpaid leave of absence. Now, as much as you may understand that part, what gets it even more confusing is our municipal benefits, such as sick leave, short-term disability insurance, long-term disability insurance, are typically used concurrent with FMLA. Remember, FMLA leave is unpaid. So employee obviously wants coming money in. So when they're out on FMLA, they are going to use their sick leave, or they're going to use short-term disability insurance or long-term disability insurance. They run concurrent. They run concurrent. All right, everybody with me so far? Any questions so far? All right. All right. So again, we have to separate out sick personal time, short-term disability, long-term personal leave. These are separate and distinct from the ADA, excuse me, from the FMLA, but run concurrent with the FMLA. So what are the FMLA triggering events? What is going to obligate us to go through the FMLA process? Does someone have a question? All right. The first is birth, adoption, or foster care. Any absence related to birth, adoption, or foster care will trigger the FMLA process. So let's say, hypothetically speaking, an employee comes up to you and says, look, I need to take 2 hours off on Friday, leave 2 hours early on Friday because my partner and I are going to see a lawyer about adopting a new baby. So yes or no, answer in the chat box, will that trigger the FMLA process? Yes or no? going to see a lawyer about an adoption? Ooh, a lot of you are saying no, but Gretchen, you said yes. Take yourself off mute. Why'd you say yes? I haven't picked on anybody yet. Come on, Gretchen. Are you there? I'm only picking on you, Gretchen, because you got the answer right, just so you know. The answer is yes. Yes. Microphone's not working. All right. Yeah, I've heard that excuse before. No, we'll let you pass, Rich. The answer is yes. Does seeing a lawyer about adoption have anything to do with adoption? Yes. It will absolutely trigger the FMLA process. Isn't going to see a lawyer about an adoption analogous to a pregnant woman seeing their OBGYN? Okay. It absolutely yes. So what are you going to tell that employee? Well, congratulations. Okay. You may be eligible for FMLA. Let's get you in touch with HR and trigger the FMLA process. That's it. Spot report and trigger. Spot report trigger. That employee is likely eligible for FMLA. Now, what's going to happen is we'll make that employee bring in the note from the lawyer saying they saw them for 2 hours about an adoption. And once that's verified, those 2 hours are going to be credited as FMLA. And that's how it works. So any absence related birth, adoption, or foster care. Judy, you had a question?
Yeah, can I ask a question about that? So it's my understanding that FMLA is timed, so there's a time limit on it.
Yes.
So triggering for an appointment, wouldn't that, or couldn't that use up FMLA time you might want to save for after the adoption?
Ooh, great question. Great question. And we actually see this a lot with pregnant women. They may be wanting to save their 12 weeks for after the birth of the child, but they may have some pre-pregnancy complications and they don't want to use FMLA. Well, truth of the matter, under the law, if it qualifies for FMLA, we can make them use FMLA. We can actually get FMLA. Now, the thing about it is, are we going to make this employee who's going to see a lawyer for 2 hours go get a note to justify this 2 hours FMLA? No, that'd be a waste of our time and money. But in more serious cases, we may actually insist that it be FMLA. Okay, we can absolutely do that. If it meets the requirements, it's FMLA. Right? Now, that's just the first triggering event. The second triggering event is when the employee has a serious medical condition. Now, people would not think like a bad case of the flu, putting COVID aside, but just the regular flu would be a serious medical condition, but it absolutely can. Absolutely can. So I want to direct your attention to the highlighted section. You get treatment for a condition that leaves you unable to work for longer than 3 consecutive days. Whether they are work or non-work days, doesn't matter. You get treatment by a medical for at least 2 times in a 30-day period. The treatment is continuing, which means it is a prescription or you're doing physical therapy. So let's say hypothetically someone has a bad case of the flu, okay, not COVID, just the irregular typical flu, right? On day number 1, from their sickbed, they call their physician. Physician orders in a prescription to the pharmacy. Family member goes to the pharmacy and picks up the prescription. They're at 4 days, right? They then get their prescription renewed because they're having some bronchial asthma type issues, okay? Well, were they out more than 3 days? Yes. Were they treated by a healthcare professional twice? Well, did they get that treatment continuing? Did they get that prescription refilled? Yes. Those 4 days get counted as FMLA. So how's it going to work out? Well, the employee's going to come back on day 5 and you're going to say, hey, how are you feeling? So, oh, bad case of flu, but I'm fine. I'm fine. And you're going to say, well, you may be eligible for FMLA. Let's get you in touch with human resources. We get them in touch with human resources. We have the employee get a doctor's note filled out, say those 4 days were related to the flu, that they were treated. And then once we get that, if it's verified, then of course, those 4 days get credited as FMLA. The other, someone wrote, if employee takes the morning off for a doctor's appointment, requesting sick leave for prenatal, how would we necessarily know that we should be charging with FMLA? Well, that's a good question, which is why for those minor incidents, we do not bother pursuing it as an FMLA issue. It's really only the substantive ones, right? Such as someone is out before pregnancy with 3 weeks for preeclampsia or digestional diabetes, something like that, something significant. Yes, we may want it, but we're going to hunt down doctor's notes for a 2 day or 1 day or just someone coming in late. I would argue it's not worth your time and effort. Right. Now, also, what would qualify for FMLA, I'm just going to highlight, is you get continuing treatment for an ongoing serious health condition. So, for example, someone is getting chemotherapy or radiation for cancer. Someone has some leg injury that requires multiple MRIs, going to the orthopedist, they cast put on, cast put off, X-rays, etc., physical therapy. That is clearly going to be FMLA as well. FMLA. So serious medical condition. I told you I was going to confuse you on this. That's a method to my madness, so just bear with me. Now, what's the third trigger event? Well, when a serious medical condition of a family member, hence the name of the statute, family and medical leave. So who's a member of family? Anybody know? I'm going to throw this out to the group. Anybody know who's part of a family for FMLA? Anybody want to guess? I got no takers here. Spouse, parent, child. Heather, very good. You got it right. Spouse, parent. Whoop, I went too fast. Where is it? I think, where is it? I thought I had that slide there. Spouse, parent, or child. So is an employee eligible for FMLA leave to care for an ailing grandparent? The answer is actually no. No. Is an employee eligible for FMLA leave to care for an ailing grandchild? The answer is actually no. Now, of course, if you are raising your grandchild, then you're the de facto parent. And of course, you're going to get that time off. How about this one? Is an employee eligible for FMLA leave to care for an ailing mother-in-law? What do you think? Yes or no? The answer is no. No, it has to be the employee's parent, the employee's parent. Aren't you relieved that you can't take time off to care for your mother-in-law? If you knew my ex-mother-in-law, you'd totally understand it. Now, there's one more triggering event, and that is care for active injured military personnel, service members with a serious medical condition or illness, and the leave is related to either themselves, spouse, child, parent, or kid. So, for example, let's say you or your spouse or your parent or your child is injured in the line of duty. Okay, well then you are eligible for 26 weeks of FMLA leave. So, with respect to your supervisor responsibility, what is your job responsibility? Is spot, report, and trigger. Just get that employee in touch with HR. Okay. Domestic partnerships, actually in Massachusetts, domestic partnerships, if you go through the legal format, you can literally have it designated. Yes, that will qualify, but you have to go through the legal process. Now, this is a chart that shows you how much FMLA employees are entitled to, and it really depends on the trigger and event. So for birth, adoption, or foster care, 12 weeks in a 12-month period. Serious medical condition, again, 12 weeks, 12 months period. Serious medical condition of a family member, 12 weeks, 12 weeks in a 12-month period, excuse me. But for care of injured military personnel, you get 26 weeks in a 12-month period. But I want to focus on the most common one, and that is serious medical condition of an employee. And I want to test you. Let's say my spouse and I are adopting a new child. And come Monday, I want to start an FMLA leave of absence for my new adopted child. How much FMLA am I entitled to? Just answer in the chat box. How much FMLA am I entitled to? Oh, Judy, is your mic working?
Got a bad
I got to
answer.
pick on you because you're the only one who got the question right.
Oh,
So why did you say it depends?
Because I know that it's a timed thing, so that's why I said what I said earlier about those appointments. So, like, I would be
Oh, Judy, you're going in and out. I think we lost Judy.
connection. Can you hear me?
Yes, it's very fuzzy though.
I'm sorry. I would caution somebody
Uh,
about what they want to take at the end of the birth or adoption, because if they're FMLA for their appointments.
You're exactly right. So let's explain it to this way. If I want to start that FMLA leave absence on Monday, if I'm a new about child, we have to go back 12 months and look at how much FMLA I've used in the last 12 months. A constantly moving, rotating clock. If I've used none, then yes, I'm getting 12 weeks. But let's say back in March, I took 2 weeks of FMLA because my son was sick and had COVID. Well, now I'm down to 10. How about back in December, I broke my leg and was out of 4 weeks on FMLA for a broken leg. Well, now I'm down to 6. How about last September, I took a week of FMLA to care for my father who had a heart attack. Now I'm down to 5. Or maybe between myself, my spouse, my kids, my parents, I've had so many serious medical conditions that I've taken 12 weeks of FMLA. In which case, how much time am I entitled for my due adopted child? 0. We only get a total of 12 weeks in a 12-month period. Okay, total. If people got 12 weeks for every single little triggering event, we would never see our employees. We just never see our employees. We only get a total of 12 weeks in a 12-month period. Now, if I haven't confused you yet, I will start confusing you now. People can take 12 weeks or whatever they're entitled to in one large block, such as after the birth of a child or after surgery. They can use it in weekly increments, daily increments, hourly increments, what we like to say intermittent leave, such as I need to take my son to dialysis every Wednesday from 1 to 3. And we need to keep track of these hours, days, weeks that we use of FMLA. But this is the important thing. Typically, that is not your job. It is typically not your job to keep track of how much FMLA an employee is using. It's not your job to determine how much they're entitled for. It's typically not your job to notify the employee when they're running out of FMLA. That is the job of human resources or whoever the consultant is you're hiring them to do that job. Your job is just to spot, report, and trigger. All right. Any questions about this? And yeah, I'm going to get to the COVID issues in just a minute. Now, a lot of times, and I just want to throw my 2 cents. I have no doubt there are some of you on this call going to say the biggest problem with the FMLA is you have employees that are abusing FMLA. They always seem to be out on Fridays or out on Mondays or out when you need them or after Tuesdays after a long weekend. And it's true that there may be abuse going on. And if there is abuse going on, we can always have that employee recertified. We can always send that employee to one of our own doctors. You absolutely have that right to do that. But I'm going to suggest to you that in most workplaces, that's not the biggest concern. The biggest concern we have at FMLA is the supervisors do not trigger the FMLA process when the employee may be eligible for FMLA. That to me is the biggest legal concern in most employers, that they're not letting the employee know they may be eligible for FMLA and we're not triggering the process. Because that to me is the bigger concern that goes on far more often than abuse. And obviously that can result in potential legal liability. All right, any other questions on that? Yeah, someone said they have a disability and they fill out forms every year. Absolutely. All right. So now let's deal with some COVID issues. And there is some COVID protection. I don't want to get into that, but I want to focus on the FMLA. Again, the FMLA protects eligible employees who are incapacitated by a serious health condition or may, as the case with the flu, where complications arise or were needed, covered family members. So we're going to treat these COVID type issues exactly the same we say any other type of serious medical condition. But let's focus on what is not covered under the FMLA. And that is when someone takes a leave for purposes of avoiding exposure to the flu. So let's say it's this employee's job to work at the senior center, and they say, "Oh, I'm not going there. I'm not running the risk of getting COVID." Well, that actually is not protected. They are not suffering from a serious medical condition. That is not protected under the law. What's also not protected under the law is employees who take off work to care for healthy children. So I know most schools in this area, I think, are back to full time, but for a while there, of course, parents had to work at home, right? Because their students, their kids were working, going to school remotely. Well, taking time off to be home with your students who are going to school remotely is not an FMLA issue. It's not. And the last one is employees caring for dependents who have been dismissed from school or childcare. So childcare is canceled because of COVID. Is that an FMLA covered event? It is not. It is not. Now, that being said, our state government, our U.S. Government of Labor has said we should broadly construe our policies, okay, to make it easy for these people to get eligible benefits. So as much as it may not be covered under the FMLA, maybe under personal leave, sick leave, paid time off, we may allow them to use vacation leave in those circumstances. So I would advise you to broadly construe your benefit policies to allow the people to get leave under these circumstances. Stated differently, we clearly don't want to punish employees when they have to stay home because of this terrible pandemic we did. Right? But when it's a legal issue under the FMLA and when it's a broad interpretation of our policies. Any questions about this at this point? All right, very good. Let's go through some hypotheticals now so you have a good understanding of this and cover some other issues. Sanvi is a 5-year employee, had a medical emergency caused by her diabetes, and has been hospitalized for the past few days. Sanvi's partner called Sanvi's supervisor to let the super know that Sanvi will need additional time off work for recovery. The supervisor then sent an email to everyone in the department about Sanvi's condition and where to send her a get well soon card. So the first question is Sanvi covered under the ADA? Yes or no? Well, we have diabetes here, so I'm going to suggest to you it likely would be an ADA issue. Is Sanvi covered under the FMLA? Yes or no? Well, absolutely. We had a medical emergency that's going to require hospitalization for a few days. It's actually an FMLA issue as well. Now, last question is the supervisor in trouble? And if so, why? Anybody have any idea? Gretchen, actually, it's not HIPAA, but you're on the right track. There are privacy concerns. Yes, it's about the get well soon card. Under both the Americans with Disability Act, the ADA, as well as the FMLA, we're obligated to keep these issues as confidential as possible. And it can only reveal that information on a need-to-know basis. So here, the supervisor is clearly violating the ADA and clearly violating the FMLA by letting them know where to contact Sanvi in the hospital, where to send them a goodwill soon card. Okay, we cannot share that information. So how about this scenario? You have an employee that's out for ADA issues, out for FMLA issues. And other employees start calling up to you and say, "Hey, where's Ed? He hasn't been to work in a couple days. You know, what's going on with Ed?" What can you tell those employees? Anybody know? What can you tell them? Call Ed? Nope, you shouldn't do that. I wouldn't appreciate that. Thank you, Gretchen. He's out. That's okay. I would simply say he's on approved leave. On approved leave. You cannot mention that he has a disability. You cannot mention that he's getting reasonable accommodation. You cannot mention anything about that medical condition. You cannot mention FMLA. The only thing you can say, he's on approved leave. That's it. That's it. All right. Any questions on that? All right. How about this scenario? Oh, so obviously, what should the manager do? Spot report and trigger, contact HR. All right, how about this one? Jack, a longtime employee, has been on vacation for the past 3 weeks. The morning Jack is supposed to come back to work, Jack calls his manager, informs her that a month ago he hurt his back at work when he tried to lift a heavy box. Jack then states he will be out of work for 6 more weeks due to surgery for this injury. Jack has no additional vacation, personal sick time available because he's used up an allotment for the year. So the question is Jack covered under the ADA disability? What do you think? Yes or no? Well, all we know is that he hurt his back at work, right? So at this point, but Heather, very good. We have a workers' compensation issue, right? So it could absolutely be an ADA issue. Judy, hold on. I'm getting there, right? Is Jack covered under the FMLA? Well, maybe he needs time off to recover. So probably yes. And lastly, is Jack potentially in trouble for anything else? And if not, what? Judy, you mentioned it. Workers' comp, fail on a report. When employees injure themselves on the job, they are obligated to promptly report this. And this is going to be a really big issue between your medical providers, between your workers' comp providers, because the bottom line is, are we going to be figuring out, did Jack really hurt himself at work? Or did he hurt himself jet skiing while he's on vacation? And that's why Jack can absolutely be disciplined for not promptly reporting us our injury. Now, at this point, since workers' comp came up, I'm going to guess that all of you use some sort of expert for handling your workers' comp. I'm assuming that. Well, just like you don't want to be handling your workers' comp, you also don't want to be handling these ADA reasonable accommodation issues as well, because they do require some really good knowledge of this information. Okay. All right. I think I got one more for you. For the past few months, Zach has been coming to work late and not meeting his productivity goals. Jack has also recently refused to complete work assignments given to him by Manuel as supervisor. Manuel has not addressed these issues because Zach is difficult to deal with. Yesterday, Zach refused to complete another work assignment. When Manuel approached him about this issue, Zach informed that beginning next week, he'll need to leave work 2 hours early every Tuesday and Thursday for cancer treatments. So, first question, is Zach covered under the ADA? Yes or no? Of course, we have cancer. Cancer. Is Zach covered under the FMLA? Well, of course, absolutely needs routine, regular treatment for cancer. The answer is yes. All right. So the answer to that question is clearly yes. So what should the manager do? Spot report and trigger, absolutely call HR. All right, very good. All right, you're getting the hang of this. Now there's a part 2 to this scenario. Manuel is finally fed up with Zach's troublesome behavior and his impact on his troublesome behavior is having on the department's productivity. Manuel goes to HR and requests that Zach be terminated for insubordination, failing to meet productivity goals, and excessive tardiness. So the question is Manuel in trouble? And if so, why? Why? Is Manuel in trouble? Chris, can I take you so case your mic working?
Yes,
Why is Manuel in trouble?
because there was no documentation along the way to demonstrate difficulties.
Absolutely. Now, as was stated in part one, Manuel didn't want to deal with Zach because he was just pain in the royal, you know what, just troublesome to deal with. But if we ignore those performance issues, then we are going to be stuck with employees forever. You have to address every performance issue, no matter how minor, in a prompt and effective way. And that includes employees who have disabilities, employees who have medical conditions, employees who are frequently using an FMLA. You can't treat someone differently or give them preferential treatment in any way, shape, or form. You have to be consistent. So here, Manuel is probably going to be sued for disability discrimination because now he's taking action against Zach after he let them know that he needs a reasonable accommodation and needs FMLA. That smells, tastes, and looks all a lot like disability discrimination. Right? Right? All right. Very good. Now, I typically, when I do these training workshops for you all have a lot of questions and answers. You want to talk to me about particular things going on in your workplaces. So I did build that into the presentation. So you are all very free now to ask any questions about anything we've talked about today or anything we didn't talk about. Game for whatever you throw at me. Anybody have any questions? And feel free to take yourself off mute at this point. Judy, I see your hands up.
I hope my connection is good now. I have a question about the most difficult personnel issue I've had to do with somebody who could no longer perform essential functions because of aging. And I made reasonable accommodations without formalizing that along the way. But I need to know how to deal with that because I suspect we're all going to be dealing with those issues as we move forward because people are working longer. And
Sure.
Personally, working in the field of aging, it was a really difficult situation for me to not be able to talk about aging during the process. So I just would like maybe some parameters.
Yep. And Judy, can I add a little bit more facts? This is a wonderful human being. They've worked for you for many, many years, right?
Yes.
And you hate to see what's going on with this employee. I just had to add those additional facts, right?
Yeah. Yes. I
totally
mean,
understood.
They worked here for a long time, but their abilities had, diminished over time. Ambulation was a real challenge, and so, there were productivity issues. But I really hated like heck to have to make the conversations about productivity and work-related issues when, from a humanity point of view, that was not the problem.
And this is probably, if not the most common, it is one of the most common issues we face at senior centers because we have employees that are elderly, right? That are employees. But I'm going to kind of approach this from two different ways. The first thing I want to approach is, remember when I had that long list of protected characteristics and there's only 3 that had asterisks next to them that would provide reasonable accommodation? Religion, disability, and pregnancy. We do not provide reasonable accommodations for age. We do not. And whether that employee is 65 or that employee is 25, we have to be consistent in how we address these performance issues. So I would suggest to you, regardless of the age of the individual, whether 25, 35, 45, or 55, we have to approach those performance issues exactly the same way. We have to be consistent. And the way we typically do that is by coaching. And if coaching is clearly not working because, as you indicated, they're no longer capable of doing the essential functions of the job, then you really have to consider terminating the employee. Because whether that employee is 25 or 65, if they're no longer capable of doing the essential functions of the job, we should not be employing them. We just should not. Because you're setting a really bad precedent for anybody who has any type of performance issues. They're going to say, well, you didn't terminate Ed, who's 65, but you're terminating me for 35 when I can't do the same issues?
So I had done progressive discipline with coaching and verbal and all of that.
Yep.
but there was no appetite from my employer to do anything about it.
And that's
They,
and
they
I
felt that the
understand that.
person was protected.
And I understand this is a pulling on the heartstring issue because you really don't want to hurt this individual, right? But there comes a time, and I understand with the employers, this sounds like a typical municipality, to be honest with you, as I know all too well, having worked for one for many, many years, that, we just continue to employees. But think of what a drain that's going to be on your workplace, what a drain it is, how you have to allocate assignments and work differently to people. You create inconsistencies in how you're evaluating or assessing people. I think it's a recipe for disaster for not taking a concrete action. It sounds like you've done everything you should do, but if the employer doesn't want to do what appears to be the right thing at this point, then I don't know what more to tell you, unfortunately. That's such a common phenomenon. There was actually, it was really unfortunate. There was an employer, it wasn't a public sector, it was a private sector company near me that had the same sort of situation. This was an employee who worked there for 35 years. And they loved this person, but he was not capable of really doing anything anymore because of whether it be age or disability, whatever. And they were so fearful and so, not fearful is the word, but they were so ashamed of having to tell the person to let go. They actually just brought me in to do just that. Just have a conversation with this person. So you remember that George Clooney movie where he flies all over the country? That's how I felt. But sometimes you have to make that decision because you have to enforce your policies and evaluate employees in a consistent manner. And if you don't treat employees consistently, it's a recipe for disaster. All right. Any other questions or concerns? Now, I just want to spend, I apologize, I probably should add a slide on this, but I do want to talk just very briefly about reasonable accommodations for pregnancy. And what the law says is we have to provide the same accommodations for pregnant women as we do for temporary disabled employees. That's what the law says. So, for example, someone has a broken leg. That's not a disability. That's not a substantial impairment. But do we give them some sort of special accommodations? Well, if we give the person with a broken leg special accommodations, we have to give them for the pregnant women as well. That also includes nursing mothers. And when those issues come up, spot report trigger, contact HR. All right, any other issues? Any other questions? Now, just so you know, I told you there was a method to my madness, and I got into this in detail because I wanted to confuse you, because I can't emphasize this enough. You have to talk to HR when these issues around, and when these issues arise. And if you don't have an HR, you have to talk to someone who's familiar with how to handle these issues, because these are too complex. You're dealing with people's lives. You're dealing with potential legal liability issues. You don't want to handle that alone. All right. Kathy, I don't see anybody else asking any questions.
No, nor do I. And thank you for covering things so thoroughly. And this concludes our training. And we will now be turning the recording device off. Thank you all for being here. Ed, thank you as always for great information.
I just want to share, obviously, if you have any of these legal issues, I can't get into this